I have to just say, representing a coal district where lots of jobs have been lost and more are expected to be lost because of these rules, we certainly feel like we're under attack from Washington, D.C., and if it's not a war, it sure is something that's pretty close to hell. Thank you. That being said, it's my understanding, and if I could get yes or no answers, I'd appreciate it. It's my understanding that you're a lawyer by training. Is that correct?
I am.
And it's also my understanding that the Attorney General of West Virginia, Patrick Morrissey, wrote a letter to Gina McCarthy on June 6, 2014 regarding these new rules. In there, I understand the EPA agrees in its technical documents filed with this proposal that under the plain reading of the statutory language of Section 111D found in the U.S. Code, EPA has no legal authority to regulate CO2 emissions from power plants under Section 111D. In particular, Section 111D of the U.S. Code provides that if the EPA is already regulating a source under Section 112 of the Clean Air Act, the EPA cannot also establish standards under Section 111D for those same sources. Isn't it true that in 2012, EPA started regulating power plants under Section 112 under its Mercury and Air Toxics Rule? Yes or no?
We did issue a regulation under Section 112.
Under Section 112. So under the plain reading of the U.S. Code, and by the way, a plain reading of the legislation reported from this committee and the substantive provisions of law enacted by the House and Senate, this decision by the EPA foreclosed, the decision to regulate under 112 foreclosed the agency's ability to regulate greenhouse gases under Section 111. Isn't that correct?
That is not correct.
And you base that upon the your new understanding that the EPA takes the position that they don't read the provisions of the U.S. Code literally because there was a technical conforming amendment included in the 1990 Clean Air Act amendments that you all assert, you the EPA assert, creates ambiguity in what is the law or about what the law is. Is that your position, ma'am?
This is not a new interpretation. This is the interpretation that the agency took in 2005 also in the Clean Air Mercury Rule, that reading of the statute.
And does do any of the following still work for the EPA? Carol Holmes, Harold J. Hoffman, or Wendy L. Blake?
Yes, some of them.
So then the court in its ruling made an error when it said that your position was the opposite of what you have just said. I read from the opinion that you referenced, that would be New Jersey versus EPA 2008 opinion. For all lawyers listening in, 517 F. 3rd 574, quote, this requires vacation of cameras regulations for both new and existing EGUs. EPA promulgated the camera regulations for existing EGUs under Section 111D, but under EPA's own interpretation of the section, it cannot be used to regulate sources listed under Section 112. EPA thus concedes that if EGUs remain listed under Section 112 as we hold, then the camera regulations for existing sources must fall. EPA promulgated the camera regulations for new sources under Section 111B on the basis that there would be no Section 112 regulation of the EGU emissions and that new source performance standards would be accompanied by a national emissions cap and voluntary cap and trade program, end quote, from the opinion that you just said where your people argued the opposite. The courts seem to think they argued what I think, and that is you don't have authority if you've regulated greenhouse gases under 112. You don't have the authority, not greenhouse gases, but regulated the existing coal-fired power plants. You don't have the authority under 111. How do you reconcile those two? Your thought that this was your position before and now finding that your lawyers had previously argued the opposite, at least if the court is not mistaken, and I note that the case was appealed on other grounds, but cert was not granted.
The camera decision was based on a completely different basis, the decision to vacate the rule.
I understand that, but you just stated here today that this was not a new position for the EPA because of this case. This case says the opposite. How do you reconcile that?
I'm not intimately familiar with the court decision that you're reading. We'll be happy to respond to this question. I'm sure we will.
I appreciate that. Let's just talk about good basic lawyering then. You know what a Scrivener's error is. You've been around the process for a long time. You've gone to law school. You understand that when a bill passes, and this committee does it all the time, when we say at the end, our chairman will say that, closes by saying the staff can make technical conforming amendments. What the EPA is hanging their hat on is a Scrivener's error that was a conforming amendment, and you're saying that a Scrivener's error and a conforming amendment should trump the law of the United States? really. With your background, your education, I would expect a better argument. Thank you very much, Mr. Chairman. I yield back.
The gentleman yields back. At this time, I recognize the gentlelady from Florida, Ms. Castro.